in Doe versus Unocal, and it was dismissed. And so that's a big gap in this. The people really responsible are not, you can't sue them. We hope that the cases are, are catalytic in the sense of creating more accountability, but they're not directly so. On corruption, it's really been more of a background context to the cases. I mean, for example, why is it that there was suppression of dissent in Ogoni? Well, it's because the government ripped off the people of Ogoni for decades, right? And exploited the people in the land and didn't turn back any of the profits, and people lived in misery. That's why, and that's all because of corruption. But it wasn't something that we could address directly in the lawsuit, but it clearly was the reason why the lawsuit existed, and it's the reason why a lot of these lawsuits come about. And let me see, the International Forum, I think that it's going to take a really long time to have an international system of corporate accountability. And I don't see any reason why we don't start campaigning now for that. And it seems to me we have to, because these kinds of cases are not going to achieve the accountability that the world needs over corporations. And I think we need to be building that structure and arguing for that structure at every point along the way, certainly now and until we have it.
Thank you. Your comments are obviously generating more questions than they're answering, so we'll do 3 and then we'll do 4 and then we will have to stop, and hopefully we can get quick comments back from Paul and Martyn.
Thank you. Benedetta Lacey from Amnesty. I echo the comments of my colleagues saying these cases are hugely important for part filling the corporate accountability gap. And from Amnesty's perspective, this is a huge concern. Paul talks about corporate impunity, and it is a gap that hasn't yet been filled. I just wanted to ask a question of both of you, since it's such a unique opportunity for you both to be sitting on the same platform, and as it seems meeting for the first time, to contrast and compare the rules around settlements in the US and the UK. A huge concern that Amnesty has around settlements are the conditions that lawyers are bound to as part of the negotiation process. And I think both of you have made it very clear that you need to represent the best interests of your clients, and that is achieving settlement. And from our perspective, we are interested to explore whether judges, for example, could be given criteria guiding them as to what is a fair settlement to endorse and what is not. So if you could say a couple of words about the situation in your respective jurisdictions, I think that would be very interesting. Thank you.
Thanks.
Hi, my name is Eli Lund. I work for the Norwegian Council for the Government, Council on Ethics for the Government Pension Fund. I was wondering, have you seen the companies change when you have taken them to court? Do you see them change for the better, and do you think the risk the companies face for facing you actually make them better? Thank you.
Thank you.
My name is Paul Scott from corporateregister.com. Many people see parallels between the former South African apartheid regime and what's now happening in Israel. And today I was part of a group of people delivering a letter to Veolia urging them to withdraw from the infrastructure projects in illegal settlements in the West Bank and in East Jerusalem. And my question is, what would be the legal parallels between possible actions against companies like Veolia, Caterpillar, etc., supporting illegal settlements and the current situation, and the successful actions brought against IBM, Daimler, and Ford that we've heard about this evening?
Thank you. So, US versus UK settlements. Do companies change, and what are the parallels between South Africa and Israel, probably? Paul, Martyn's nominated you.
Okay, well, on the rules regarding secrecy, first, let me go in order. Unless it's a class action in the United States, the court has no supervisory authority over private party settlements. And so if private parties want to settle with secrecy or other restrictions, they can, and they do. And that puts us in a difficult bind. I mean, there is a conflict, I think, between what would be good from an overall human rights perspective and what's good for the clients. But I think Martyn and I are in clear agreement that as lawyers, we represent the clients. Now, we also, it's easy to say that, but you know, a lot of times clients also look to us for guidance, and I've been involved in a lot of political cases over the years where clients will not accept those kinds of restrictions based on their own political views, and they will give up a settlement that might be in their interests for a larger objective. But I think ultimately that's the client's decision to do. Now, the other thing is that one of the ways that Amnesty or others can get involved in that process, particularly in the United States, would be to create rules that prevent certain kinds of agreements. For example, you can't, under the rules of professional responsibility as a defendant, require a plaintiff's lawyer not to sue that company on behalf of somebody else in the future. I mean, that's just a rule. And so when we're asked to do that, which we are, we say, well, you're asking us to commit an offense, so we can't. And so if there was a rule that said you couldn't, the court has to decide whether a settlement is confidential or not, well, then it's taken out of the hand, you know, out of your hands, and that might or might not be a good thing, depending on how you look at it. Do the cases change corporate behavior? I'd like to think that that's the case. I mean, I don't know that I have a lot of empirical evidence to show that, and maybe that's a question that Chris may want to talk about more than us. I think that it has in some way. I think companies in the United States are very aware of Alien Tort Statute cases, and they're very aware of what might get them sued. And I think over time that starts to affect corporate behavior, but you know, I don't have an empirical response. On the South Africa and Israel issue, I don't really want to get into whether they're equivalent situations. I don't know that I think that's not something that I would really be prepared to debate. But the one thing I would say, at least in the United States, is that because the United States supports Israel in so many ways, the Corey versus Caterpillar case is a perfect example. That case was brought against Caterpillar for supplying bulldozers that were specially designed to knock down houses in violation of international law. And the appellate court found that the case could not be heard because of the political question doctrine. And the reason for that was U.S. support for the sales of the bulldozers to Israel. And so the court found that that was not, given the U.S. government support, the courts could not hear that case. And I think that that's in almost every case that's been brought against Israeli companies or companies that are doing business with Israel or against Israeli officials, it's been impossible to win, just as a practical matter. None of the cases have won.
Thanks, Martyn. Very quickly, you can just say you agree and stop there.
Yeah, so just very quickly, just in terms of the rules against secrecy, Paul's absolutely right, is that I think unless there was a formal rule that said we as a law firm could not enter into an agreement that meant that we could not act for people in the future on the same sort of case as a part of our ethics of the law society, whatever, it means that, you know, we're always in that position where the client says, yeah, well, that seems good to us, and you kind of get forced into it. But I think that if the rule was there, then it would just stop it in its tracks. Secrecy is more difficult, confidentiality is more difficult. It's difficult to quite determine who would be best placed to do that. But I think Paul's probably right that in the end, if in the end the rule was that the judge has to give authority to it, particularly where there are minors, then that might be a way of getting around it. But it's a massive issue and gets bigger all the time in our jurisdiction. Second, in relation to what was the second point, corporate?
Do they change the
Oh, yeah. Again, you know, it is very difficult as a practitioner because each time you're bringing a different case, so it's difficult and you don't massively follow what has happened to the previous, the company that you've taken on. But I like also to feel like Paul, that we do make a difference, that companies do go to